For years, Meta and YouTube insisted their platforms were just neutral tools, digital playgrounds where people simply chose how to spend their time. But a court has just shattered that defense with a devastating ruling. These companies knew exactly what their algorithms were doing to children's developing brains, and they did it anyway. This verdict could change the internet as we know it. Welcome to Court Decoded. Today we examine the landmark negligence ruling against Meta and YouTube, a case that finally held big tech legally responsible for engineering addiction in children. The courtroom fell silent as the verdict was read. After years of litigation, mountains of evidence, and testimony from dozens of experts, the jury delivered a message Silicon Valley never expected to hear: guilty of negligence. Meta, the parent company of Facebook and Instagram, along with YouTube, were found legally responsible for the harm their platforms caused to young users. This was not a slap on the wrist. This was not a settlement hidden behind non-disclosure agreements. This was a full public accounting, a jury of ordinary citizens declaring that two of the most powerful corporations on Earth had knowingly designed products that damaged children's minds for profit. The implications rippled far beyond the courtroom. Hundreds of similar lawsuits sat waiting in courts across America. Lawmakers who had struggled for years to regulate big tech suddenly had legal precedent on their side. And parents everywhere finally had validation for what they had long suspected. To understand this case, one must first understand the machine at its center, the algorithm. These are not passive systems that simply show users content they might enjoy. They are sophisticated artificial intelligence engines designed with one purpose: to maximize engagement at any cost. Internal documents revealed at trial showed that engineers at both companies understood a fundamental truth about human psychology. The brain's reward system responds powerfully to unpredictable stimulation. Slot machines exploit this. So do social media feeds. Every scroll presents the possibility of something thrilling, validating, or shocking. The brain releases dopamine in anticipation, creating a cycle remarkably similar to gambling addiction. For adult users, this design is troubling. For children and adolescents, whose prefrontal cortexes are still developing, whose impulse control mechanisms are not yet fully formed, these algorithms created what experts described as a perfect storm of psychological manipulation. The companies knew this. The evidence proved they studied it extensively. The plaintiffs in this case were not statistics or abstractions. They were children who had experienced devastating psychological harm. Families came forward describing teenagers who had become completely consumed by their devices, unable to sleep, unable to focus on school, unable to maintain real-world relationships. Some developed severe anxiety disorders, their self-worth entirely dependent on likes and comments. Others fell into clinical depression after exposure to algorithmically amplified content promoting self-harm. In the most tragic cases, parents testified about children lost to suicide after spiraling down rabbit holes of harmful content that the platform's algorithms actively promoted. The defense argued these were isolated incidents, that millions of young people use social media without serious harm. But the plaintiffs' attorneys presented a different picture, one where the company's own research showed they understood the population-level damage they were causing and chose profit over protection. The turning point in the trial came when internal company documents were presented to the jury. These were not leaked memos or second-hand accounts. These were official research studies, executive presentations, and internal communications obtained through discovery. One meta presentation from their own research team concluded that Instagram was making body image issues worse for 1 in 3 teenage girls. Another showed executives discussing how to respond to studies linking their platform to increased rates of depression and suicidal ideation among adolescents. The response was not to change the product, it was to suppress the research. YouTube documents revealed similar patterns. Engineers flagged that the recommendation algorithm was promoting increasingly extreme content to young users. The autoplay feature kept children watching for hours beyond what any reasonable parent would allow. When researchers proposed changes to protect minors, documents showed these suggestions were rejected because they would reduce engagement metrics. The jury saw executives choosing quarterly earnings over children's well-being, documented in their own words. For decades, technology companies operated behind a seemingly impenetrable legal shield, Section 230 of the Communications Decency Act. This law, passed in 1996, protects platforms from liability for content posted by their users. Big Tech had wielded this protection like an invincibility cloak, arguing they were merely neutral conduits for user expression. The plaintiff's legal strategy in this case was brilliantly crafted to work around this defense. They did not argue that Meta and YouTube should be liable for any specific piece of harmful content. Instead, they argued something more fundamental, that the platforms themselves, their core design, their algorithms, their engagement-maximizing features, constituted defective products under traditional product liability law. This was a crucial distinction. Section 230 protects platforms from liability for third-party content. It does not protect them from liability for the design of their own products. A car manufacturer cannot avoid liability for defective brakes by arguing that drivers cause accidents. Similarly, these companies could not hide behind Section 230 when their own engineering choices caused harm. The plaintiffs assembled a formidable team of expert witnesses. Neuroscientists explained how variable reward schedules activate the same brain pathways as addictive substances. Child psychologists described the developmental vulnerabilities that make adolescents particularly susceptible to these design patterns. Former tech industry employees, the people who built these systems, testified about the deliberate choices made to maximize addictive potential. One former product manager described meetings where the psychological impact on young users was explicitly discussed and dismissed as acceptable collateral damage in the pursuit of growth. Another explained how features like infinite scroll, autoplay, and push notifications were specifically designed to override users' natural stopping points. The defense brought their own experts, who argued that correlation does not prove causation, that social media use has benefits as well as risks, and that parents bear primary responsibility for monitoring their children's technology use. But the jury found the plaintiff's evidence more compelling, particularly the internal documents, showing the companies knew their own defenses were false. The company's defense strategy relied on several key arguments, each of which proved increasingly difficult to maintain as the trial progressed. They argued their platforms were used safely by millions of young people. But the plaintiffs showed this was like a pharmaceutical company arguing a dangerous drug was fine because some patients did not experience side effects. They argued parents should monitor their children's use, but evidence showed the platforms were specifically designed to be used without parental knowledge, with features that hid activity and notifications that encouraged secretive checking. They argued that changing their products would violate users' free speech rights. But the plaintiffs demonstrated this case was not about speech at all. It was about the delivery mechanism, the algorithmic amplification, and the addictive design patterns. Most damaging was the company's struggle to explain their own internal research. When executives were confronted with documents showing they knew their products harmed children, their explanations rang hollow. The gap between what they said publicly and what they discussed privately was simply too wide to bridge. The verdict sent immediate shockwaves through Silicon Valley. Stock prices for major social media companies dropped as investors calculated the potential exposure from hundreds of similar pending lawsuits. But the financial implications may be the least significant consequence of this ruling. This case established a legal template for holding technology companies accountable for product design choices. It demonstrated that Section 230 is not an absolute shield. It proved that juries will hold corporations responsible when internal documents reveal they prioritized profits over safety. Already, lawmakers are citing this case in proposals for new technology regulations. State attorneys general are examining whether to bring additional actions, and perhaps most significantly, other industries are watching. Any company that designs products using psychological manipulation techniques, from video games to gambling apps to streaming services, now operates in a different legal landscape. The era of consequence-free algorithmic manipulation may be ending. The jury found Meta and YouTube negligent in their design and operation of platforms they knew were causing psychological harm to children. This landmark ruling established that technology companies cannot hide behind claims of neutrality when their own research shows they understand the damage their products cause. The verdict opens the door for countless similar cases and may fundamentally reshape how social media platforms are designed, regulated, and held accountable. For families affected by social media-related harm, this case provides not just vindication, but hope that the legal system can adapt to address harms that did not exist when our laws were written. The central legal lesson is clear. Knowingly designing an addictive product and marketing it to vulnerable populations creates liability, regardless of the medium. If you found this case breakdown valuable, subscribe to Court Decoded for weekly analysis of the legal battles shaping our digital future. Share this with someone who needs to understand what big tech knew and when they knew it.